Hi, I'm Smruthi. I head legal at Strata, and today we're here to talk about some of the legal items that you should be cognizant of when you're investing in real estate. So let's go through some of the basics of due diligence. When you're conducting a legal due diligence of property, there are about 5-6 main pointers that we will walk you through today that you can be looking at. Title due diligence of the property would involve looking through the property papers, where you can check who the owner of the property is, how that owner got title to this property, and you generally do this exercise by going back over 30 years because that has something to do with what the limitation laws of India talk about. So 30 years would be a safe period to review title papers of the property. Survey records are also very important. Now, survey records, when I say, I mean they're government records, which reflects what's on the title papers. It should reflect the same measurement, it should reflect the same boundaries and such. These are basic main pointers that I'm talking about. Of course, this is a much more in-depth exercise, but we move on to the next aspect, which would be revenue documents. This is another government set of records. Here you look at whether the revenue records that are maintained by the government are updated and accurate to reflect the same owner that has been reflected in your title flow. For example, the current owner of the property is also the current owner on the latest khata of the property. It would be your khata, your patta, your satbara, depending on which state you're doing the due diligence for. The compliance with all statutory requirements is another important aspect when you're looking at built property. For compliance with statutory requirements, we mean looking at the zoning, whether it's in a commercial zone if it's commercial property, whether it's an industrial zone, and they are accurate for the zoning of that area, whether the builder who has built that building has complied with all the relevant building bylaws, has obtained all the approvals, whether environmental approval was required, whether fire and OC was required, whether any such other, the OC is in place. These are important aspects that come under your compliance aspect. Disputes is next. This is a big thing. The litigation system in India is not evolved enough that everything is online. There are so many records, so many court records that will be in the physical format. So you should always ensure that you have done a litigation search. That is, your consultant would have gone to courts and would have gone to the sub-registrar's office and checked whether all the records are in place, whether there are any outstanding pending cases against your property, etc. So these would be basic pointers to help you look in the right direction when you're doing due diligence of a property. Post this, what we should also be mindful of would be in a transaction. Now you have completed your due diligence and you are getting into this transaction for acquiring this property. You should ensure these main items, that the legal due diligence is complete and is reliable. That is, when you have done your due diligence, your advisor has been prudent enough to have done a proper job of it, has been diligent enough to have checked all the records that are required. You have gone to somebody that you can count on, whose opinion you can count on, whose reputation you can count on. So that's important. The technical due diligence would be when you are acquiring built-up area. You might have to bring in your consultant and check what the measurement is and check if the construction is as old as they say it is, older, if there are any leakages, if there are any items that would cause you to spend more money on the property, then you should definitely be well informed of that. This will help you negotiate a better price. This will help you ensure that you are ready to take on and you're getting into what you know completely about. The next thing would be whether the documentation is kosher. Now, when I say that, I mean if you're entering into a sale deed for acquisition of the property, say the owner from your title due diligence is X, but who is selling to you is Y. That can't be, right? So the documentation should be kosher, that the correct parties have executed it, the execution is proper, you're entering into the correct document, that it is a sale deed where it has to be, the lease deed is in place where it has to be, the transaction is structured correctly. So that is something that you should definitely look out for. Next would be about pricing. Pricing being realistic is an important point, but how you go about this might be a little tricky. So you must definitely not go with just what one broker is saying or what the buyer is saying, because there will definitely be a gap in what everybody says. You should, maybe one useful thing to do is to make sure that you have looked at the recent transactions in the area and you are aware of what the market price in that area is. Apart from this, stamping and registration requirements are very important. When you have entered into a sale deed, it is required to be registered, for example. And when you have entered into an agreement of sale, under RERA, it is required to be registered. Otherwise, if it's not under RERA, then maybe just stamping will suffice. So there are a lot of intricacies with all of this, and you should ensure that your documentation has been stamped and registered as required. Now we will move on to pre-leased properties. This is, of course, the most lucrative asset class to be acquiring. Pre-leased properties are rent-yielding properties that will give you rental return from the day that you purchase it. So when you are entering into a pre-leased deal, these are some of the basic things that you might want to look out for. The type of document that has been executed by the owner and the current tenant is important. Just ensure that whether it is a lease deed, whether it is a leave and license agreement, whether it is just a rental agreement of 11 months, what kind of document is executed, is that the correct documentation for the understanding that you have. The lease period, the lock-in terms, these are important to ensure that you have calculated your returns correctly. If the lease period mentioned in the lease agreement is, say, 3 years plus 3 years renewal at the option of the tenant, but you have been represented by your seller that it is a 6-year lease, then there is definitely a gap in your understanding and what they are representing. So ensure that these terms are very clearly recorded in your rental document. Rent, escalation, security deposit are all the commercial aspects of it. You must make sure that all of these are clearly laid out in your document with the tenant. Security deposit is always refundable. You should ensure that you are not refunding the security deposit before they are leaving the premises, etc. You hold on to the security deposit when they vacate the premises and you have done inspection to ensure that there are no deductibles from the security deposit, and then you refund it. Things like these are the terms that you should be mindful of in any pre-leased asset, so that there are no surprises there. Force majeure is another important item. Force majeure means any act of God or any situation that is not in the control of any party to that contract. Now, if there is an earthquake and there is damage to your property, or if there is a pandemic and there are government restrictions on your tenant running their business in the property, these are items where you should make sure that you're comfortable with the terms put in force majeure. Maybe some clause will just say that if there is force majeure, the tenant gets to terminate. Maybe that is not fair to you as a owner of the property. Maybe you should be given sufficient time to cure the breach or to cure if there is damage. You should have the time to cure that damage, and then they should continue with the lease, because force majeure is neither party's fault, right? There might be loose language which just says that pandemic is a force majeure condition and they get to terminate at that. Maybe you should put in more stringent clauses, such as if there is a government imposed lockdown, and that is what becomes a force majeure, not just the existence of a pandemic that doesn't even affect the area or something like that. So you should make sure that you're comfortable with such terms. Rental delay penalties, you should make sure that you have recorded rental delays from the tenant would incur some penalties on their part. Termination rights, you should ensure that they cannot terminate during the lock-in period. They cannot terminate at the first sign of force majeure. They should give you enough time to cure any breach or any interruption with their possession, etc. before they can terminate. You should ensure you have enough termination rights to say ask them to vacate in the event they have not paid rents for a consecutive period of 2 months, 3 months, whatever is the commercial understanding between you. So these are some of the main items that you can look at, but you should ensure that you have gone through this lease document end to end, because now you are stepping into the shoes of the current owner, of your seller. So you will be bound by everything that seller was bound by.
I hope that was helpful and you got some insights into the legal aspects of real estate investing. If you still have any questions, please leave them in the comment box, or if you can always visit our website. Thank you.